All right, so still not on yet. That's weird. There we go. Okay, so we took a break. Let parties review my ruling on the motion to strike surrebuttal of witness Kell. So let's get on the record. We're not already on the record. So yeah, just to recap, this is docket 5780 TE 111. And we are now dealing with the procedural portion of the question we had regarding admitting the surrebuttal of witness Kell. We'll need to provide, we need to know how we'll proceed today in order to be able to vet all the new evidence we've received. Does anyone have comment they'd like to make initially, or should we just get down to talking about the schedule? Just anyone want to start there?
Yeah, Your Honor, if you don't mind, I have a comment and maybe a question and a
Okay.
point of clarification.
Okay, great.
To the extent it has not been clear throughout this proceeding, I represent SBU and only SBU, and am only speaking on behalf of SBU in this proceeding. One question that came up, Your Honor, PSC 2.27 identifies the timeline for interlocutory review of a ruling made at a oral hearing as tomorrow. I think we would be very curious to see the transcript of this hearing before considering our options, and are curious if there's a way to, is it possible to file a placeholder motion?
Yes, that can be done. Sure. I think I've seen that in the past. I mean, I'm not really the decision maker in terms of interlocutory review process. So I can only tell you, I guess, what I've seen in past practice, and I believe that has occurred where motion's been filed sort of like a placeholder to indicate the desire to file a motion for interlocutory review, and then requesting that there be more time to supplement that. I think the commission at its discretion will have to decide what to do in case that's the process you wish to follow.
Thank you for that discussion. And
Mhm.
then we were also curious about the amount of time that commission staff needs in order to respond.
Thank you. I have that. So next week, Tuesday, is the soonest that we can realistically be ready. And that is the 14th.
One suggestion we had, Your Honor, was that we could take Mr. Stawicki up today. It doesn't sound like anyone has any cross for him at this point, and sort of get his testimony in verified. And then, subject to further discussion here, maybe continue the remainder until it can be rescheduled.
Okay. All right. So any other alternative suggestion? No, I'm not hearing anything. So I guess it just to have him, the witness Stawicki, take the stand now, and then have the witness verify testimony. I would probably want to reserve that for the full hearing, just in case there's more questions that come up that staff renew, or if there's additional testimony SBU wants to add by witness Stawicki. It seems like that witness's participation won't take very long, so to do it on the day where we handle everything else shouldn't burden that process. So I'd rather just take all witnesses on the day we're prepared to hear all the testimony, rather than kind of than splitting that up at this time. So any other So we're thinking a idea we would be, parties would and staff would be prepared to address the full range of issues no sooner than Tuesday, the 14th. Is that what I'm hearing?
That's correct. And I am wondering about Whippy's participation here. How is that how does that
Well,
factor in?
Oh, yeah. Go ahead.
I'm sorry, I didn't hear the question, Ms. Rogers. How does that affect?
How does that factor into the schedule?
Well, in my mind, we don't have any. I mean, Whippy can certainly bring its attorney to the hearing. Otherwise, I didn't contemplate there would be much more for Whippy to do since the testimony's already been filed. If there's if there's additional process we need to take, because Whippy is now a party, I don't really think, I'm not anticipating there'd be really anything more for the record at this time. And I guess I would expect someone to tell me that they need to do something different now that Whippy is a party. So I didn't think that would change the process in this proceeding much.
And Judge, I haven't thought it through. I'm more thinking out loud.
Sure.
Flagging the issue. I do wonder if Renew intends to pose its discovery request to Whippy once it's made a party. I don't want to overcomplicate things, but I'm trying to understand better how this affects our evidence.
Right. And I wasn't anticipating that opportunity in this case, but I guess I'm open to hearing whether more process needs to occur to get a full record. I thought we were kind of in a tacit agreement here that what was being presented in writing so far was largely the extent of what we needed to see in this case. We just need an opportunity to vet that. That could involve discovery on Whippy witnesses, but that was already possible. So let me hear anything additional. It looks like Attorney Vasek has a hand raised, so go ahead.
Yes, Your Honor. I think from my understanding of your previous ruling, the Cal Exhibit 14 and the accompanying Section 5 are included, assuming that there's proper response. So to the extent that there's not, I guess if there's an interlocutory appeal of that ruling and it's decided that the request wasn't properly addressed, but I think the information is public anyway and now available. So I don't anticipate, aside from a strange legal situation, needing to issue a slew of discovery to WPPI. I don't think that would be necessary or appropriate here, unless for some reason it's compromising the basis of that information.
Mm-hmm. Okay. Okay, so I think what we probably just want to do is set a hearing date then. And it's a little tricky next week. Yeah, so next week we could start on the 14th. We may not finish. I do have a hearing. Well, so I have a hearing at 11, which doesn't doesn't makes things a little tricky here. We could start at 10 and reconvene, break for that hearing, reconvene throughout the day. Probably don't want to start much later than why don't we start at noon on the 14th, and then we'll see how much time we need after that. I think we'll probably have to then push it to the 16th in order to reconvene if we need to do that. But I'd rather just go through without interruption for the 14th to the extent we can do as much as we can all at once during the day. How does that sound?
Mr. Mellemans is not available in the morning on the 15th. Did you say we would potentially continue into that day? He could,
No, 15th is booked. So we'd have to move to the 16th.
the 16th, sorry. There is a commission meeting.
Yes, that's right. We can still hold a hearing during that time, though. It's not a problem. If we're on Zoom. So we started at noon on the 14th, take as much as we can till the end of the day. If we need to spill over to another day, that would be 10 a.m. on the 16th. Can everyone handle that? Or should I just give you a minute? Let me know.
We can make that work, Your Honor.
That's fine, Your Honor.
Okay, great. So we won't have a new notice go out, and we'll just be reconvening. But I will add an item to the calendar, to the electronic calendar. Otherwise, I think we're looking like things are ready to go. I don't know if we have anything else to resolve at the moment. No, we have another hand raised. You can just chime in, by the way.
Sure.
You don't need to raise your hand.
I just to nail us down here on procedure, because last time we were having this conversation, we left it a little vague, and then potentially that caused some of the problems we have now. So you mentioned additional testimony from SBU. Is that in addition to the things we received today? Or are we limiting that to what we received today? What is the thought there?
Mhm. Well, the way we usually proceed is that every witness gets to make a statement on the stand, responding to what they've heard, responding to the last round of file testimony and what they may have heard at the hearing. So to the extent I understand the process right now and feel like I'm more confused than ever, the SURSA rebuttal appears to be SBU's last submission of testimony. So that would be, it'll be received as if spoken at the hearing. We'll have to review it. There's actually some filing errors. We'll have to take note of that before we begin, but also at that point, I don't think when an SBU witness hits the stand, they'll have anything else to say because they will have already made that response to the last testimony that was received by that was filed by Renew and staff. So I think that's how we'll proceed at hearing, and then obviously Renew and staff would be able to make a brief oral statement responding to the SURSA rebuttal, but hopefully nothing, nothing too elaborate. And I would encourage you to do that live on the stand. It's not a treatise, not a display chart, but just some basic responses to what we've heard, what was submitted in Sir rebuttal. And then we'll take it from there. I mean, I guess the ultimate goal is to make sure we get all the information, a complete record with opportunity to vet the information being provided. So, you know, at some point that has to end. But also at some, you know, we do want to be flexible in order to make sure we do get substantial evidence on the record from all sides and avoid repetition. So at some point it becomes repetitive. So you have to be careful to note that when you're making a response. So I guess I won't say anyone's precluded from further testimony, but there's got to be a reason. It's got to be probative. It's got to be not repetitious. So that really does, things get very narrow at this point in this stage of the process. So we all have to be cognizant of that. So I don't know if that helped, but that's probably the best answer I can give you.
Thank you, Your Honor.
All right. So anything else? All right, we'll meet again then, May 14th at noon. Thanks very much, and we're adjourned.
Thank you, Judge.